Okay, with that said, I appreciate your indulgence on those two items, gentlemen. We need to get taken care of quickly. Chester, I think we'll go ahead and have you explain. This board will be set as a Board of Equalization and Review to hear an appeal. And Chester, would you, for the board's prospect, explain that? You explain it to me and just explain exactly what we're doing tonight.
Grab my file real quick.
And gentlemen, you received in your advanced packet, I think it was a 4-page brief from each side of this, and you have that, and I'm certainly some of you have read that. It's an executive summary, if you would, from Shawnee Meadow Holdings, and then a response from Macon County Tax Office. So, just with that said.
Just very briefly, this is a matter that involves a petition by a taxpayer to the board. Is authorized to make what we call discoveries if and in the event that we find that a property that has been listed does not include all of the improvements, for example. Sometimes you will have a situation where the tax listing form shows something as being a piece of vacant land, for example, and somewhere along the line there may have been a building constructed on it, and that building obviously increases the value in most instances of the real property, and hence the taxable amount. If it's not shown on the tax listing and it comes to the attention of an assessor, the assessor is charged with the statutory obligation to pick that up and make sure that it is included in the valuation so that that property is properly taxed. In this particular situation, a limited liability company by the name of, I believe it's Shawnee Meadow Holdings, LLLP, had a piece of property in Highlands, I believe is where it's located, and or is located, and there was in fact a discovery done by the county's tax assessor on that because of some improvements to the property when it came to commercial building structure that did not get picked up for tax purposes. That discovery was done. Shawnee Meadow Holdings, LLP, notified of the discovery and basically has taken issue with the way that matter has been handled and some values as established by the tax assessor for that piece of property. And pursuant to General Statute 105-312, that taxpayer has the right to petition this board to consider the possibility of compromising, settling, or adjusting the county's claim for taxes arising from that discovery. On behalf of Shawnee Meadow Holdings LLP, I believe we have Mr. Boger present.
Yes.
If you would stand and just introduce yourself to this board.
Richard Boger. This property is owned by 3 family partnerships. We sold some farmland that had been in the family for generations in 2005 to the lifetime exchange for this parcel and a couple of others on the Highlands Management Plateau. It was a piece of raw land purchased in 2005 for $245,000. The property is located on 4th Street in Highlands, North 4th Street on the Cashers Road. In 2006, we applied for a building permit, and I worked with Hank Ross's landscape architect at that time, he was on the town board of Highland, to do the water runoff. Worked with the building permit, came to him, was the builder, and the building permit from the health department in Macon County late 2006. Worked with the zoning board and the town board again on occupancy. It was given a certificate of occupancy, 50% completed in the spring of 07. there are a lot of quirks here that come into play. First, as everyone knows, the county deferred any formal reassessment of property through 2 cycles, and it was only this past January that the latest reassessment of the property was done. The last was on January 1 of 2007, during which time the building was under construction. The tax card that was written on January 1 of 7 had a nominal value for a building for a fence that I think Joe Breedlove and I question whether it's even on the property, but it was land only at $323,000. That was a 40% increase on January 1 of 07 from the date of purchase, which was mid-2005. I looked at the bottom line, felt a 40% increase in the land. Property values were going up. I had a building under construction. Figured that was appropriate. The taxes are approximately, based on that card, $1,300 a year. This past year, with changes in the millage rate and so forth, it went to 14. In August of this year, I got a letter from the county on the discovered property issue, and they valued the property, the building and the land at $984,000 versus the $323,000. Under the terms of the statute, you may use the discovered property value for the current year and go back 5 more years. On that, you are assessed interest, penalties, and so forth. So on a property that we have been paying on time and regularly $1,300 to $1,400 a year in taxes, I was given a $22,000 tax bill. That got my attention. So I contacted the county, and Joe Breedlove was here, came out, and we walked the property. The building was built. I don't want to get too much in the weeds, cut me off if I'm getting there, but these are significant facts. The building was built as an unfinished shell with a certificate of occupancy given on the first floor that was framed in, had sheetrock, plumbing, and everything but the electricity turned on. In 2011, the Highland Central Baptist Church, which was a spin-off from the First Baptist Church in Highlands, needed a place to meet and rented the space and finished it with paint, carpeting, and so forth, no significant improvements, and have been a tenant since 2011. I agreed with the county, and I can't thank Tax Assessor Richard Leitner and Joe Breedlove and Teresa for working with me on this, because it is a very complicated thing. I'm not a real estate professional. I'm retired. I was in the insurance business for 30 years, but not in the real estate business. I do own property in Georgia and North Carolina, and I've had experience in a couple of other states. This discovered property statute is an interesting one, to say the least. I'm not putting the statute on trial. Let me get that straight. I don't disagree with the statute. I don't disagree that additional taxes are owed. I'm appealing on 2 grounds. One is fairness, which is an overriding trait or characteristic or requirement for ad valorem taxes. Fairness meaning that the value that's assessed is comparable to the fair market value of the property. The second thing, as Mr. Jones said, is language in this particular statute which gives the Board of Commissioners or their designee, which would be the Board of Equalization, the opportunity after all is said and done, to compromise, adjust, negotiate, whatever, with the taxpayer. The taxes were paid, ended up with the revised value on the building. The taxes were $12,000 and change, paid in full, 4 hours late on the second day. I got a $250 late charge because one of the partners lives in Florida and sent her tax check through the U.S. Postal Service and got way later than that. But those are the two grounds on which I'm appealing. In January, after several discussions with the tax assessor's office, Mr. Leitner suggested, well, why don't you get an appraisal on this property as of the 1/107 date? You can't use current numbers, you can't use numbers for 2010 or anything else, but it's the date that we're talking about. The base date here is 1/107. I thought that was the proper way to go about it. I have Mr. Rick Robeson here, right behind me, who did the appraisal, did a summary appraisal. It's not bound and sealed and everything else, but we came up with what I felt was a fair market value for the property. The numbers worked out at the end of the day. The county felt the total value was $674,000. Got at that value with $354,000, I believe, on the building, and added that to the land, $323,000. And that's what we discussed for much of last year, and it came down to what I thought was a reasonable solution, and that is to get an appraisal to see what the land was really worth. Mr. Robeson came up with $340,000, I believe, on the building, and $250,000 on the land. So we're apart today $87,000. Now that doesn't seem like we're that far apart. It is 14%. It's not insignificant. But when you apply interest and penalties, the numbers mount up substantially. Furthermore, the day after I met with Mr. Leitner in January, he called me. We had a very candid discussion the day before. He called and said I might be willing to waive the late fee. So that number, 250, is on the table before the commission. I do not know the total tax savings on the $87,000. We'd have to push the pencil on that. Perhaps someone from the assessor's office knows the number exactly. I'm guessing it's in the $2,000 to $3,000 area, possibly, over this 6-year period. Mr. Robeson, we paid $1,500 for the appraisal, so that is on the table too. If the commissioners would prefer to have it bound, sealed, and delivered, I can pay another $1,000. We can have that formally presented as part of the minutes today. So that's basically my speech and background on this. I think I'm reasonable. I again can't thank the assessor's office enough. I think they've been reasonable in hearing me out and going through this. I gave an executive summary of what I just said. I'd be happy to pass out. It was included. I did provide that to the assessor's office in late February, I believe, was increased, so we can schedule this meeting.
Each member's got a copy of it.
Thank you. Okay. So with that, if Rick, would you have anything to add on the appraisal?
It's pretty short.
Yeah, I'll just let the final part. Not seen that.
We have to connect with the
said, my name is Rick Robeson. I'm a real estate appraiser. I've been in Western North Carolina for the last 20 years. Prior to that, I was in Florida for 18. Mr. Boger asked me to help him understand what his property was worth on January 1st, 2007. His property is a 13,000 square foot lot with 5,476 square foot. In the handout, you'll find an aerial front and rear photograph of the property. I searched for sale of commercial use property located in the Highlands Market, but outside that downtown core because he's not in that downtown core. It sold prior to or near January 1st, 2000. I found 5 sales. You'll also find those sales in your handout. And basically, they sold for $142 to $267 per square foot of the building area, including land. To make a long story short, I thought a value of $170 a square foot for his 5,476 square foot building would have been appropriate for a value as of January of 2007. But that calculates to $930,000. But the building was only half finished at the time. I also found that the land value was reasonable at $250. So if you take the total value, it would have been, had it been finished, and subtract $250,000 from that, it would give you a building value of $680,000. But again, it was only half finished. So my calculation value for the building at that time was half that, or $340,000. Add back in the $250,000, that gets you to $590,000. It's all explained there, the math calculations and everything. I think that could answer your question.
Bronson, did you see the property in January 1, 2007?
No.
And on what are you basing your understanding that the steepness is complete at that time?
Mr. Boger advised me of that.
And what did you understand the improvements consist of?
The first page of what I've given you says that it's a 5,476 square foot building by my measure. That is 50% complete. I have inspected the property. It's still not finished. The second floor is not finished at all. The first floor is finished with the improvements that Mr. Boger described as fairly minimal, but they were not there on January 1 of 2007.
You're saying the structure was complete, but that the interior finishing work was not complete?
The shell was fine, the inside was fine.
Is any roughing done, any plumbing, wiring?
First floor.
Only.
Yes, and I'll say that I have no dispute in value on the building. It is in total value that was assigned versus, this is the fairness issue, versus the value of the property as of 170 or 87,000. But it's not in the building. Joe Breedlove can speak to it. He saw the building and has inspected it on behalf of the county and came up with the 50%. And
Mr. Robertson, in the appraisal world, what is considered what percentage is considered a decent appraisal? 5%, 10%, 30%? You have a variance, right?
You could, yeah.
What is that variance? On most cases, you've been in the business for how many years?
38.
So you should have, so it can vary from what, 10 to 15 to 30 to what? What would you recommend? What would you think?
I wouldn't venture to answer that question. This all depends on.
But you agree that appraisals do have a variance?
Sure.
And it could be 10%, it could be 14%, it could be 50%, depending on the appraisal. Right?
I'm not going to comment.
But it has a variance, correct?
Joe, anything else?
Boger,
yes,
did you at any time take the value of the real estate? I think you indicated that you improvements and the amount that was assigned to the improvements, the building, the commercial structure, if you will, you have no dispute about that value, is that correct?
No, in the handout that I passed around, we have a difference in that. And that led up to the January discussion when Mr. Leitner said the only way we can resolve this issue on land, there's a letter in the file that you had.
But back to my question.
Wasn't opposed.
You're not raising a question about the amount of value that the county has placed on the actual commercial structure, are you?
Mr. Beal's point, $14,000 is difference on a $350,000 building. We have a difference, but it's not material.
You're focusing primarily on the value of the land upon which this building sits. Is that correct?
Correct. The 07. What was the fair market value? What was it assessed at on 1/1/07? Subtract that, and you come up with discovered property.
For the years beginning 1/1/07 through and including 2014, did you ever make a request to the Board of Equalization and Review to change the value of just the real property?
I made no request, and that I plead ignorance to. If I do pay a good bit of property tax. I'm most familiar with the state where it operates a little different because every January you get an assessment. You have 90 days to appeal it each year. In North Carolina, because of the perfect storm, and 2 successive cycles went by as permitted under the ad valorem tax code, no reassessment was done. So, as I said in my earlier remarks, when I got a 40% increase in only 18 months of ownership, I felt that was reasonable and did not appeal.
This is the first year that you've raised that value question.
Correct. I did not know about discovered property until mid-August when I got the letter from. This is August the 14th.
Thank you.
You're welcome.
Okay. Mr. Lockton. We also received a attached gentleman, about a 4-page executive summary. Don't make any next.
Okay. First thing, it's not 2 cycles. We valued the property January 1/07. He started construction, actual construction, in the summer of 06, which time field workers had already completed for the 07 value. So when 07 value was still out, the building was there. Then, in process for the 2015 value, we found it during inspection. So there's only 1 cycle since it is passed. Secondly, under North Carolina law, and the case interestingly comes out of Henderson County, and in that case, I believe it's Bell, they had went and built a house in 1996, I believe, and the county discovered it in 2010, I believe. There was 2 appraisal cycles. Property Tax Commission ruled that even though the taxpayer had gotten all the permits from the county and the city of Hendersonville and all the permits from the health departments and everything else, the law specifically says in North Carolina that that does not constitute informing the tax office if you add or delete it from the property during the year. And that's the reason in North Carolina you have to run an ad to the county every January saying if you delete it, add it, or change your property, you have to list it with the tax office. So the courts have already ruled that. In the second case, Morgan case was decided right after that case, also out of Henderson County. And in the Morgan case, it goes on for a number of years, and the county went and found out a piece of property was built on. Well, the owner came in and told the tax office during these years that they had improved the property. The appeal court has ruled in North Carolina, which is still case law because it didn't go any higher, that even though they came in, the county can discover, or it wasn't called a discovery, it's called immaterial irregularity. So the county could go back 10 years or further. So either way, the county is protected and the burden is always shifted to the taxpayer. That's not what we want to hear. That's not what we can endorse. That's nothing we can change. It's what we have to live within. So both of those cases support the county. Now going back to the discovery under 312, the notice of value says you were listed with, say, $100,000 on your property. It says you have a new building, $200,000. Your new value is $300,000. The difference is $200,000 you owe on that building. As Mr. Jones asked the taxpayer, that building wasn't there, but he received the bills, he paid on the land, he had every year to come in and question the value on the land. Also, the value in North Carolina, unlike the way Mr. Robertson appraises, or Mr. Duval, or anybody else, or myself, as I said, fee appraiser, we take the square footage, some sells for it includes the land, and we come up with the value of the land and building. Well, for taxes in North Carolina, we have to break it out. So when he does that, he's doing two things. He's taking one value, breaking out the land, and it so happened that the land was purchased for $245. Mr. Robeson now is saying the land's worth $250 in 07, but he's abstracting that out from a property that's sold. The 5 properties were approved properties between a price range of $140 and $225 a square foot or thereabout. Thirdly, that property was certified by the town of Highland, meeting their codes. They got the occupancy. And it wasn't 50% complete because you have to look at the usage of that building. That building is not going to be 2,600 square foot on the bottom level, 2,600 square foot on the top level. Under the codes and the ordinances from the town of Highlands, they were commercial on the lower level, 2 apartments of 750 square feet on the upper level, and then that's 1,500 square feet, and you probably figure another 400 or 500 square feet of entryways, hallways, and that there. So you're at roughly 4,600 square feet. But you got 2 different types of uses. You got a lower retail level, which is premium, and you got a apartments lower. Mr. Roberson and his numbers there has taken off because we didn't have 20 parking spaces for that type of building, 4 per 1,000 square foot, I believe. However, under the ordinances in Highlands, his building and parking's correct because he's got 2,600 square feet downstairs. You figure that out, that's about 10 and a half spaces. You got 2 apartments upstairs, that's 2 per that. So that's 14 and a half, 15, he's got 15 spaces. So he's taken off deduction, which the town of Highlands has given an authorization to use that building. So you really can't take off deduction because that's what it is built at. And lastly, if you use Mr. Roberson's numbers, he used the lower end because of that deduction, saying it's 50% complete. You take the 2,600 square foot downstairs and the percentage upstairs at he can use, it's more than that. If you go to the bank, Macon Bank, First Citizens, anybody, when you build a house, you get the roof on, exterior finish on, the windows in, it's 50% complete. So he's got a higher percentage complete because of the occupancy downstairs, which is an assembly type building. So when you do all that, the difference isn't that. So what I'm saying is, first off, the land wasn't in question. It's the building. We took down the building because he did have some upstairs unfinished. We did not use the inventory irregularities because he was required to list it, so that goes in discovery. And even in discovery, the years 7 and 8, he should have been paying taxes on, and he didn't pay taxes on that because we can't discover those back. But, you know, morally or anything else, we know that we didn't pay taxes on those 2 years. And actually, part of the third year. So, I don't think he has a case based on everything that he's presented. He didn't show us what that, this appraisal was, a summary appraisal, and if you use that there, it didn't really show you the comps and where they are. It didn't show the overall price of that building because he gave you a round ballpark figure of $250 on a piece of land. Is that high or low? Just so happened to use the lower square foot price to come up with a number which $250 fits in real nice. So under all those conditions and based on the Bell and the Morgan case out of Henderson County, I don't believe he has a case with us. As going to the part of the power of commissioners to compromise a discovery, you do have that power. That's the only place in the Machinery Act, and there is no guideline. But the guidelines are this. If you do it illegally, you five have to come up with the money if somebody questions it. And then, I've been here 30 years in the tax office. We have never done it on any discovery because you set a precedent. So that's the only two things I would, put at the end of this. It's up to you. You can do whatever you want. You do have that authority. Has never been done in Macon County, so to be set.
Did this appear before the Board of Equalization, City Board of Equalization?
It came after the Board of Equalization, so since they closed down, you are the board.
So they didn't see that?
No, it came in July. Yeah. And it's a 2014, it's not a 2015. He has a question on 2015, that's on the new day, and that goes to the Board of Equalization. I'm sorry? No, from here goes to the state superior court. No, Raleigh, if he chose to.
So, just get down to the Bryce tax rate to make sure I understand. You're saying he owes $12,000 in taxes?
He's paid the $12,000. Now he's wanting, the difference at $87,000. I think if you do the.
How much money is that?
I think, well, the money's not that much. I think it's like $1,500. But then he throws in these other things that you have no authority over, like the appraisal fees and attorney fees or anything like that. Even at the state level, you don't get that back. We don't get that back. Taxpayer don't get that back.
Sure, additional information.
Yes, in your packet is a letter from Mr. Laser to me dated January 23rd of 15. And if you notice, first I put a disclaimer in the first paragraph of the thing that this is an administrative hearing, it's not a legal hearing. And it is in the first paragraph of that letter. It says, since our last conversation, I have talked to Ms. Janet Shires, General Counsel for the North Carolina Property Tax Commission. She informed me that the taxation of your building is not a discovery. but an immaterial irregularity, as allowed under 105-394-3. I am not, number one, I didn't seek out legal counsel. I'm not litigating this. I'm appealing on the two grounds that I suggested: your ability to compromise and negotiate a settlement. There are no parameters on that, as Mr. Leitner said. You can come up with anything you want. But to throw another statute, 105-3943, at me in January, after I had secured the appraisal that he asked for, is outside the scope of this. And then to admit that it's really not a discovery, but an immaterial irregularity, it changes the whole basis for why I got the letter in the first place. I got it on code 105-312, discovery. So I would say that while it's nice to know what they did in Hendersonville and in Morgan County, it's not applicable to my situation. I'm here on discovered property, 105-312, fairness, fair market value, and subparagraph K of that statute that allows the commission or its designee, Board of Equalization, to grant whatever compromise, negotiation, and language is spelled out that it chooses. So I just don't think that's relevant to what we're here for.
Gentlemen, clarification, the county did not treat this matter as an immaterial irregularity. In fact, the way the county treated this was as a discovery, just as he has asked for. In fact, I don't think Mr. Boger wants this treated as an immaterial irregularity, because if he did, we wouldn't be talking about 6 years. Going back 6 years, we'd be talking about 8.
Wherever it started.
So it's in his interest for it to have been treated as a discovery. That is the way it was treated. And the cases that were cited had to do not with immaterial irregularities, but in fact had to do with discoveries.
Thanks, sir. Any questions from the board? Comments?
What is our role in that? The role is to determine whether or not you seek the desire to compromise or adjust this discovery. And if you choose not to, then that's the end of it. If you choose to, then you've got to decide how to.
Is this liability on our part if we move the wrong way? We do that prior to a legal opinion?
Well, I think you've got the right to compromise. I would caution you, there's apparently an opinion from the Department of Revenue, an individual in the Department of Revenue that indicates that once these taxes are paid, I believe that Mr. Baker has taken the position that your right to compromise is then over once the taxes have been paid, and in this case, the taxes have been. I think there's been a court case that has determined it is a point that was published in a book that is published by the Institute.
Should not have been notified of that on January 6th. When I paid the taxes, it was a heads I win, tails I lose. I mean, heads I lose, tails I lose. If I don't pay the taxes, I'm liable for penalties, interest, and everything. If I do pay the taxes, do I not, under this statute, still have the right to appeal?
I think you can. I think if you choose to move forward beyond whatever ruling this board makes, if you're unhappy with what this board does, I think you could potentially bring a case in Superior Court challenging the outcome.
But you're saying that Mr. Baker said, if you pay the taxes, those cards are played. You have no appeal because you pay
But I
the
think
taxes.
we are here.
You are here.
So I think
That's not for
one
me to
man's
decide.
opinion. Right, but I think the statute, I didn't read anything in the statute that says my right to compromise expires when I pay the tax.
Well, this brought to our attention, we decided to hear it.
Okay, thank you.
Mr. Boger, I had the pleasure, or when we call it the pleasure, to serve as chairman of the Board of Equalization for you for many years. And I think we're all in agreement. I don't think nobody on this board, I don't think Mr. Lightner will not tell you the machinery act in North Carolina is adequate, needs redone and reviewed. It just keeps adding to a book that's now. So, with all that being said, a very good history of trying to teach the taxpayer properly and through the years. So, with that, I'll make a motion, Mr. Chairman, that we deny Mr. Boger's claim and deny his petition for compromise on the taxes.
We have a motion and a second. You've heard a discussion on that motion.
One point of clarification, you're saying that if Mr. Boger has paid his taxes, our right to compromise has been eliminated?
No, I'm not saying that. What I'm saying to you is my understanding that Mr. Baker with the Department of Revenue takes that position.
Mr. Baker, what's his title for?
Director of the tax, local government division.
There is what historically, where I had crossed this path is where there has been a property tax appeal to the property tax commissioner. Mr. Baker has served in a sense, sort of like a mediator, if you will, to help the parties see where the strengths of their cases are and where the weaknesses of the case is, and try to bring them to a closure.
The taxes have been paid.
Yeah. Well, I'm saying the fact that we paid the taxes did not bring it to this board.
Well, now, there's another part of statute in the part that allows for him to request a refund if taxes have been taken up to 5 years, 6 years after the date that the cover is. No, they changed it to now discovery 5 years. So you can't, I mean, even so, you can go under that part and refund it back if you're saying that the value is incorrect. I mean, there's more than one statute you can use. But your power to compromise would be under 312. Power to refund tax already paid is under 370.
That would be a separate issue.
And again, I'm caught totally unaware of all these little statutes out here. The one I was taxing.
I think you're thinking of 105.380 and 105.381.
Jim, you heard the motion in the second. Any other discussion on the motion?
Since the Board of Commissioners made a resolution delegating authority granted by this subsection to the GS 105-322 to the Board of Equalization.
That's good.
You can't go back.
No, we can't go back. This is 2014. The Board of Equalization quit meeting in May of 2014. This came up in July, August. So since they're not meeting, it's you guys. You are acting
We
as
are
board.
the,
Of course, there's a new value.
we are it.
So Mr. Boger can still bring the same issues up for the current year.
Not this issue. He can bring it up under the new value.
He can bring
This
it,
is not the new value.
He can contest the new value before the equalization.
It's been a year ago.
16, 15, 16.
Because this is 15.
Yeah.
On this property, we went through this. That's all.
any other discussion? All in favor of the motion, say aye.
Aye.
Opposed? That motion passes. Thank you, Bill.
Thank you all for your time. That was a long, involved, no problem. I appreciate your patience.
Thank you.
Thank you.